Is now in session.
Right, I think we're ready for our next case, if you'll call that, please.
Yes, Your Honor. State of Tennessee v. John Bassett.
Welcome back, Mr. Hedrick.
It's good to be back, Your Honor, like a bad penny. If Josh Hedrick here for the appellant, if I may have 2 minutes time for rebuttal argument, may it please the court, John Bassett's conviction should be reversed on the grounds that the evidence is insufficient to support the conviction. And also we argue that his sentence should be reversed on the grounds that the proof is insufficient to establish the aggravating factor that the murder involved torture or serious physical abuse beyond that which was necessary to produce the death. I'd like to focus my attention on that second point regarding the aggravator and its application. And then if any remaining time exists, we can talk about the sufficiency of the evidence. So in this case, the question before the court is whether the murder in this case involved torture or serious physical abuse beyond that which was necessary to produce death, where the death was caused by a single gunshot wound to the head, and where there was no medical evidence of other trauma to the decedent's body. I'm sorry to keep fiddling with this, but I'm trying to find the sweet spot.
That's okay, I appreciate it.
So in this case, the medical examiner testified that the cause of death was a gunshot wound to the head. It's a single gunshot wound to the head. A contact wound, meaning, and of course, as the medical examiner uses a contact wound, maybe not necessarily touching, but at least very close. There was no indication of any other injury to the decedent other than that gunshot wound. So the trial court, the state at trial and the trial court in dealing with post-trial motions relied on the allegation of a prior assault to support the heinous, atrocious, or cruel aggravator, which we assert is error, because the heinous, atrocious, or cruel aggravator, we know from Williams, the 690 Southwest 2nd, 517, specifically 529 in the Reporter, a Supreme Court case from 1985, we know that the aggravator must refer to the murder itself and not attendant other issues or other problems that may have happened. And there's a long line of cases which I sort of surveyed in the brief where we see the way that is applied by the courts to things that may have happened in previous transactions compared to things that may have happened at the moment of the homicide itself. And I know it likely isn't necessary, but for my own personal benefit, I want to be clear that what we're not talking about, we're not taking the position that there is good homicide, but only that our law draws a distinction between the especially heinous, that every killing is unlawful, every killing is heinous. But our Supreme Court, for example, in Odom, took the time to point out that in the Odom case, which I cited in my brief, that no doubt this was a terrifying and horror-filled experience for the victim, but that alone is not sufficient to establish the especially heinous aggravator. And in Odom, the Supreme Court said it may have been, and we have no doubt it was, but that alone is not enough. So when we think about the prior day's argument, the state sort of has two angles to try and make this work. The first one is Robert Davis testified at trial that on the prior day he observed an argument between Mr. Bassett and the decedent, in which Mr. Bassett was alleged to have held her by the throat, said, "I'll kill you," and then left and was gone for about 10 minutes before returning. In analyzing that, we have to weigh that evidence. First of all, we don't concede that that is properly considered, right? As an initial matter, that is a separate transaction that is not part of the homicide, and therefore, under Williams and under our law, could not establish that terror, that fear, that torture. First of all, because it's a separate act. It is on a separate date. There's an intervening time period. It is not the act or the transaction that produced the death. Second, it is not in itself inherently especially aggravated, especially heinous, especially when we compare it to things like Odom, for example, and the other cases cited in here. And third, there are significant questions in this proof about whether that transaction actually could have been observed, or whether Mr. Davis was even talking about the same people. Because Mr. Davis describes where he was and where the people were. The other person who was present at the time, is Tatiana Jones, told the jury that no, her car was being repaired on the totally other side of the parking lot. It wasn't there at all. It was on the far side of the parking lot under the tree, because she recalled sitting in the shade of the tree while Mr. Davis was working. And then we combine that with Officer Cooper's testimony, when Officer Cooper testified that he would not have been able to see from one point to the other. Because Officer Cooper was asked, if you were here, would you have been able to see what was going on at the apartment? And he said, no, because there's a pool, there's the brick wall, there's the entire apartment complex, there's too much stuff between them. And so we can compare Exhibit 3, which is a map, to Exhibit 7, which is Exhibit 3 is the map that Mr. Davis referenced, and Exhibit 7 is the map which Officer Cooper referenced, which is, and Exhibit 6, which is Officer Cooper's body camera. So respectfully, we don't have to take anyone's word for it. We can watch Exhibit 6 and look at the body camera and see what you can see from these relative positions. And I'll put to you that if you watch the body camera in Exhibit 6, you will not be able to see the other side of the parking lot, because there's a swimming pool in the way. If you haven't had the opportunity yet, the parking lot is a sort of on a hill. And so the swimming pool is built into the hill, if that makes sense. And so given that inability to see, given the conflict in the witness testimony, and most importantly, given the fact that this is a separate transaction, this cannot be the enhancement. Because it is not part of the murder. It's not part of the homicide. So
wasn't there some testimony that the victim's skull was in fragments and some other things that would have supported?
So my memory from the review of the record, Your Honor, is that those were related to the exit wound, or related to didn't mean exit wound, the gunshot wound. That the gunshot wound had fractured the skull. I would have to look back to be sure, but my memory is that there was not any testimony that drew a distinction between. I think you were correct that there were fractures to the skull, but I don't recall any testimony that drew that said this was separate and apart from being shot in the head. So the state then next turns to the evidence of blood in the apartment, and so if I just by way of a little bit of background, the way the investigation proceeded was some of Ms. Kyle, who was a decedent in this case, some of Ms. Kyle's relatives became concerned that they hadn't heard from her in a while. They went to the apartment to check on her. They brought an officer with her, and they found she was not there, but her dog was, which they thought was unusual for her to have left the dog alone, and that began the process of investigating what has happened to Ms. Kyle. So they end up searching the apartment, and they find some blood stains in the apartment, both that end up being both a match to Ms. Kyle and also a match to Mr. Bassett. There's mention that the television has a footprint on it, and the television has Mr. Bassett's blood on it. But there is no proof in the record to establish any kind of timeline for that evidence, right? And the state urges that, well, there must have been something going on because there's blood in the apartment, and therefore this must have been a torturous thing for Ms. Kyle. But that is pure speculation. There is no proof to suggest that at all, because we have no idea how old this blood is, and we have no idea if it's even from a single incident. We have no idea if it is from a single incident. We have no idea which blood is first. So if you've recovered blood from Mr. Bassett and you've recovered blood from Ms. Kyle, you sort of have to make a decision then. Is what if Mr. Bassett's blood was spilled first? And what do you base that decision on? What if Mr. Bassett's blood was spilled first and Ms. Kyle's was spilled in self-defense? Well, how do we know which was spilled first? How do we know if they were spilled on the same day? We can't establish an aggressor. We're literally just guessing. And then we have to layer on top of that the fact that the record does affirmatively establish that Ms. Kyle has in her history appeared unwanted and uninvited at Mr. Bassett's house and attempted to break in, smashing a window and cutting her hand in the process. So the record affirmatively establishes through Exhibit 40, in Exhibit 40, officers respond to her being in Mr. Bassett's driveway, and the fire department is bandaging her injured hand, and the officers talked to everybody and determined that she showed up at Mr. Bassett's house, and he didn't want to talk to her, and so she smashed a window to try and get in, and when she did that, she cut her hand. She called a relative. The relative called 911, said, "You got to help her. She's bleeding everywhere." The officers said to Mr. Bassett, "What do you want us to do?" And Mr. Bassett said, "Look, guys, I don't want her to go to jail, but she can't stay here. Can you just ask her to leave?" And the officer said, "Look, lady, you can't be in his driveway. You got to go someplace else." And so she did. So with that background, it makes the questions of where does this blood come from a little more muddy, in the sense that the record establishes that we have someone, and I say this with respect, but we have someone who has a history of somewhat irrational actions.
Well, let me ask you this, Mr. Hedrick. And first of all, thank you for pointing out earlier when it comes to this aggravator. I think it is important to note that, of course, every homicide is heinous, atrocious, and cruel. And what we're doing here is just a clinical look at the statute and the case law. So I appreciate you pointing that out. But when you talk about, sometimes drawing the line between reasonable inferences and speculation, it can be difficult. Does the event that occurred the day before, could that color some of the evidence that was found inside the apartment? And could that lead a juror to make the reasonable inference that there had, in fact, been a struggle between these two during that time, as the state suggests?
So I have to concede that it is possible. And in doing so, I recognize that weighing the aggravator is treated the same in our law as weighing the sufficiency of conviction evidence. And so we have the same rules relating to taking inferences and the effect of the jury's verdict. I have to concede that it is possible that the jury could infer from the prior incident that there is trouble between the two, and could infer from the prior incident that Mr. Bassett had, at a minimum, had anger towards her and expressed anger towards her and had grabbed her and had yelled at her. The trouble is stretching that into a place where we know exactly what happened in that apartment. And by that, what I mean is there is blood. Blood doesn't necessarily tell us that something happened. And so I'm going to speak about this very clinically, mindful of what you had said, but if we imagine a scenario, if we infer a scenario where someone is shot in an apartment, let's say that she's shot in the closet of the apartment, and there's clearly an effort to clean up the crime scene, because the record indicates that there was a cleanup in progress. In fact, that's part of the things that were suspicious to the officers. Is that blood that's later recovered is that blood transferred during the cleanup? Is that blood transferred by the assailant? Is that blood indication that something happened in a place? So for example, let's say that there's blood on the wall. There's a spot of blood on the wall. Does that mean that someone was struck there? Does it mean that someone was hit there, someone was shot there or stabbed there? Or does it mean that the person who did the shooting, while cleaning, got some blood on the wall? And we don't know. And that's why I say the speculation gets a little out of hand. Because what we're talking about is just making an assumption that if this transaction happened the previous day, then the blood here must be blood from an assault and not blood from one of these other causes. And that is a bit of a difficult stretch because of the intervening act and because there doesn't appear, and it is a little unusual, honestly, in this case, it doesn't appear that there's anyone who reports the actual murder happening. And so I would say that it is unusual that no one reports a ruckus that would cause the blood to be on the walls. You would think that if there's enough of a fight that there's blood being spattered throughout the living room, that a neighbor would say something. But on the other hand, there may have been a gunshot that no one reported. So it's sort of a roundabout way for me to say that it is possible to make an inference, but that inference is very strained because we really don't, we have to, in making that inference, exclude these other possibilities that are really, that are not they're not insane.
If you can draw the inference, though, doesn't the standard of review require us to view all the evidence in a light most favorable to the state when discussing the presence of an aggravator? I mean, just like in a jury verdict, right? And so if you can see that the inference could be drawn, that it's one of several reasonable inferences that may be drawn from the record, maybe not the only one, but maybe of several, don't we have to credit that in favor of the verdict then?
I think that you have to walk that fine line between. I think you have to walk a very fine line, which I'm trying to do, between accepting that there's testimony to believe that. So initially, I would suggest to the court that we should be very skeptical of the testimony of Mr. Davis.
But that's not drawing the evidence in the light most favorable to the state.
It is.
Right?
It is not.
So whether we want to or not, we're bound by the law to do that. So viewing the evidence in the light most favorable to the state and drawing all reasonable inferences in favor of the I-5 aggravator, with the concession that there is a reasonable inference to be drawn, doesn't that kind of give up the ghost?
Well, perhaps I go too far then. I mean, I think that you can.
I can't back out now, counsel.
I think you can draw. My problem with that inference, the reason why, and perhaps maybe what I mean to say is it isn't necessarily reasonable. My problem with that inference is that it covers a lot of ground. It covers more than just an inference that, if you drew an inference that there was domestic assault going on, or you drew an inference that the two had an argument, but to turn that previous day's argument into an explanation of multiple people's blood in the apartment without any knowledge of when or where or who was first. I mean, I think the question is, which inference is more appropriate? Is to infer that she was mad about the argument?
Well, on appeal, it may be the inference that supports the verdict.
But it has to be reasonable.
It does.
And so I think that where I'm leaning my pressure is on the question of whether that inference is a reasonable one, or whether that inference, when I talk about speculation, I think maybe what I'm trying to say, and I only got to it after the red light came on, but I think that what I'm trying to say is when I talk about speculation, what I'm talking about is an inference that does not pass our reasonableness floor. So it isn't just any inference we can come up with, but a reasonable inference, and that I think is where we have difficulty. Thank you.
Thank you.
Thank you. General?
May May it please the court, John Bledsoe on behalf of the state. I will focus, like counsel, on the sufficiency of the evidence to support the especially heinous, atrocious, and cruel aggravating circumstance, the hack aggravator, as it's sort of referred to at times. And I just wanted to start just pointing out, highlighting to the court, of course the court knows this, but the definition that the state is tethered to is that you have to show that it involved torture or serious physical abuse beyond that necessary to produce death. And torture is defined as the infliction of severe physical or mental pain upon the victim while he or she remains alive and conscious. So it's a focus on how the offense is being carried out. Now, this is a sufficiency review. It's whether there's any reasonable juror could make the conclusion under reasonable inferences. Also, I don't think this necessarily, I think it's important to highlight that we don't require specific elections of like what theory that is being relied upon. It's, is there any basis any reasonable juror could find any portion of that definition met? And it's going to be satisfied in terms of satisfying the sufficiency analysis that the court relies on in post-judgment, the trial court, and this court relies on.
So would you concede that this would be a unique or a novel application of the I-5 aggravator? I mean, the way I understand the state's theory is that I've got a single gunshot wound to the head and then abandonment of the victim, where the victim may have survived at least for some time following, and the defendant did not render medical attention.
Yes.
And that strikes me that we have here, I mean, we're not dealing with the pre-89 I-5 aggravator where we had a depraved mind.
Right.
This may be evidence of a depraved mind. And so you have not conduct by omission, but you have omissions that can satisfy the depraved mind aspect. But the post-89 I-5 aggravator doesn't have that. And it looks like, I'm not aware of another case where the failure to act or an omission itself arising from a single gunshot wound to the head satisfies the I-5 aggravator.
Your Honor, I think what's important is that it's several different individual pieces of fact, and that is one piece, but you look at it total. It's not just the conduct during the commission of offense, although that's part of it.
I mean, your friend on the other side says that's what we're limited to.
Actually, I disagree with that.
Okay.
I want to try to tie in, and I hope this is responsive to Your Honor's question to opposing counsel about the pertinence of the assault before. We're not saying this was a continuing offense from the assault the day before, but what happened in the assault, again, if the jury were to accredit the testimony of Mr. Davis, that he heard the defendant tell the victim, grab her by the throat, throw her against the wall, and tell her that he will kill her. There's also physical evidence in the home of blood from both of them, including his blood on the wall, the footprint on the television. You also had testimony from the aunt of the victim that she kept a neat house. Now, he testified that injury was like a month old. But a jury could infer that she would not leave old blood just on her walls. That if there's evidence of his blood throughout her house, that would indicate a physical altercation between them during this event. And this is occurring, again, from the position of the victim, one day after he has told her he will kill her. And we submit a reasonable juror could find that involved severe physical or mental pain upon the victim while she remains alive and conscious. That is part and parcel of the altercation that culminates in not just the shooting, but then her dying from the shooting. That's where I think it's pertinent, the lead up to it, and what a reasonable juror could conclude that she is experiencing during that altercation that we have physical evidence of, that a reasonable juror could conclude and infer occurred during this event.
Is there any case law authority that supports an expansive reading of the I-5 aggravator like that?
Well, it's about applying the facts to this particular.
I agree. I understand the argument. That's why I'm asking. Do you have case
I don't
authority
have a
that
case
support
that is specifically tied to these facts. I mean, some of the cases discussed below, like the King case where you had an ongoing rape during the death.
This is not like
we
King,
don't
though.
have
This
that.
isn't King.
Right,
No.
right. I'm not equating those. We don't have one specifically like that, but that doesn't mean that applying the Jackson standard does not lead to the result that the factor doesn't apply. We're looking at whether there's any reasonable inferences that support this definition being satisfied based upon the evidence. I acknowledge it's a close case. The parties discussed that below at the motion for new trial hearing. But we believe that based upon the minimal level of review that the court may engage in, that the inferences drawn here are reasonable and can support that.
So help me with how long did in the record, what does the record establish about how long the victim survived the initial gunshot wound?
We know that over a span of, I think it's 14 minutes, he had at least 9 Google searches between 11:48 p.m., 12:02 a.m., leading over into the 20th, that relate to biting of the tongue, how long someone may live. A reasonable inference drawn from that, in fact, I think the only reasonable inference, is that those searches were made at a time after she was shot and before she had died.
Okay. Do we know that on the basis on the timing, though?
I think you can infer that based upon the questions.
Okay.
The first one, how to keep person from biting tongue.
It's necessarily, though, an inference that we're drawing.
Yes,
okay.
it is an inference we're drawing.
Is there any medical evidence that suggests that the victim survived the gunshot wound?
Yes, Dr. Maluznik-Polchin testified that based upon the trajectory of the wound, first of all, it did not strike the brainstem, and it did not strike the sinuses that include the venous blood that would lead to massive bleeding, because it's injury to the brainstem and bleeding, that it's the swelling of the brain is going to then impact the brainstem that leads to death. So based upon the specific trajectory of this bullet, it was not immediately fatal. It was ultimately fatal, but it was not immediately fatal. It would come after the swelling of the brain that would lead into the base of the skull, into the brainstem, and the blood that would lead to death.
Where's the limiting principle here? Where's the limiting principle? So if I'm taking the argument and I draw it to its logical conclusion, every homicide that did not result in an immediate death, it seems like would be a candidate for the I-5 aggravator under the state's theory. Is that true?
I think it's going to turn on, well, it's going to turn on how the person is acting. Because you have this individual who's just doing searches and nothing else. But it's not just that. And that's one of the very clear.
There's no, as Judge Hickson says, all of these crimes are heinous. All of them are.
Right.
There's not additional torture, it appears, by the omission. I mean, the gunshot wound, torturous itself, but not additional torture beyond that, as we saw maybe in Keene. I mean, help me with the limiting principle. It seems like with the state's theory, we would turn almost every homicide that did not result in immediate death into a life without parole situation.
I think the answer is we're looking at what the victim is experiencing during the commission of the offense. And that's why it's both the inferences drawn from the altercation leading up to having a gun put to her temple, and then and it's reasonable to infer that during these 14 minutes, she is still alive and conscious. We have testimony from Dr. Maluznik-Polchin that she would have had loss of bodily function. She could have had seizures, which might be biting.
Let me put it another way.
Yes.
And I'm sorry, and I don't mean to interrupt, but let me put it another way. What is it the defendant could have done then that would take this outside of the scope of the I-5 aggravator? So you're saying he's running Google searches and is not seeking help, but what if he called 911? Would that mean the I-5 aggravator is not present?
If he takes some sort of action where he's like sort of helping comfort her or something, it might impact what a reasonable juror can conclude about what she is experiencing in the moment.
I mean, the victim is still in the same condition, right? And so whether the defendant is calling 911 or doing other things like that doesn't affect the presence of the I-5 aggravator, does it?
It may not, but we're going to look at everything that she's experiencing, including before the shooting. I mean, I'm not relying on just that piece of information.
The day before the shooting?
No, I mean in the altercation leading up to the shooting, the events that fit within this criminal event. That we think it is an individualized assessment of all of those facts. I don't dispute that this is a narrower issue presented the court than some of the prior cases that have been presented. The facts are different. But if you take the facts and what inferences are reasonable, this isn't speculation, this isn't assumptions, but it's something that a trier of fact could reasonably glean based upon Dr. Maluznik-Polchin's testimony.
So let me remove the state's view of the fact of an assault. Let's say I have A shoots B, B does not die immediately but lives for 14 minutes. Is the I-5 aggravator applicable?
If that's all the facts we have, I don't think we have the facts.
Okay, let's assume A does not call 911 or otherwise render assistance. Is the I-5 aggravator applicable?
Just those facts, no.
Okay. What else do I need then in that situation for the I-5 aggravator to be applicable?
We need to know what the victim is experiencing during the entirety of the event. Not just from the shooting on, but in the events leading into the event, and also after, as long as the person is alive and conscious.
Well, that was part of the hypothetical. So B lives for 14 minutes following. I-5 aggravator on that fact alone is not applicable?
Well, if the victim is alive and conscious and the person is not even attempting to render any type of aid, I think that could be.
Okay.
I think that could be.
So A shoots B, B is alive for 14 minutes, conscious, B does not render aid, I-5 aggravator becomes applicable under the state's theory. What's the proof here that the victim remained conscious?
The inference that can be drawn from the Dr. Maluznik-Polchin's testimony that there was a loss of bodily function, but the jury could infer from that she was alive. I mean, we know she was alive, but that she was also conscious as well.
I mean, except that she didn't testify that she believed the victim was conscious, right? I mean, are we just on another
She was
reference?
not asked that question specifically. That's correct.
Okay.
We believe that based upon her explanation of what she was experiencing, would be sufficient for legal sufficiency analysis purposes. That is a reasonable inference that the jury could draw.
Okay.
But again, we're not focused just on the post-shooting. And I acknowledge it's a little different with the premeditation sufficiency issue, where you kind of have to establish the premeditation existed before the shooting. But this is really looking at the totality of the actions until the offense itself is completed, until she is deceased. We believe that the evidence is sufficient for that. As for the other issue, we rely on our brief unless the court has further questions with regard to the sufficiency. Thank you, Your Honors.
Mr. Hedrick?
I was having a thought, and it was an unusual experience for me. I'd like to refocus our consideration of the other blood in the apartment, because the parties seem to have settled in at trial that the shooting occurred in the closet, and so there's blood where the shooting occurs, and if there's a shooting, there's going to be blood. So we can take that blood and separate that out from our blood that tells us something about what else is going on. That only leaves, if we look at page 148 in the transcript, it leaves a small amount of blood on the lip of the bathtub, which, again, the bathroom of a home is a place where people may cut themselves shaving, people may have other difficulties, or if you're cleaning up a crime scene, it would not be unusual for you to be making use of the bathtub and its water source. And then the other place that the blood is found is on the door frame. If we take out Mr. Bassett's blood, which is on the television, the other place where they found blood is on the door frame to the door of the house. And so unless the assertion, what we'd have to do is we'd have to infer that there was some assault occurring in the doorway that left blood on the door frame, and that's not blood that was left there by some accident as the killer's cleaning up the scene or leaving the house or something like that. When we're talking about blood in the apartment, I want to be careful that we don't give the impression that there's just blood sprayed throughout the apartment. There is 2 places other than the place where the shooting occurred. The other issue is, and in my last few seconds, I'll say that we should not adopt a rule that makes running away heinous, atrocious, and cruel. That if the rule is that failure to render aid is heinous, atrocious, and cruel, then everyone who does a shooting and then runs away is heinous, atrocious, and cruel, and that can't be true. If the rule is that you must do something to render aid, then the distinction is in Mr. Bassett's favor, because he doesn't run away. If we take the state at its word, I have some dispute with it, but if we take the state at its word, he doesn't run away. He attempts to find a solution to the problem on Google. It may not be the ideal response, but it's better than nothing. So if that's our focus, then perhaps he is better than the man who shoots and runs and leaves the victim without any aid whatsoever. Thank you.
Okay. Thank you both. You'll call our last case, please.